Sarah, I think you might be on mute. Can't hear you.
Test, test, test.
Yes, that's good.
Apologies, everyone. Yeah, if we can move to the next slide, please, Jen. Afternoon, everyone. So today and the next one, yeah, we're looking at compensation events. I'm not going to say anything about that bullet point, just leave you to mull it over. And if we can move on to the next slide, please. Okay, so these are the issues that we're going to be looking at. I am going to look at the compensation events themselves, but I just want to kind of look through the process that we have. And we'll see when we go on to the next slide that this process that I've set it down here pretty much follows clauses 61 to 65 of the contract. So clause 60 lists the compensation events. So I'll come back to that in a minute. But assuming as a contractor or subcontract, you've reviewed the list and you've decided that there is a compensation event, maybe more than one from the list, this is the process that needs to be followed. So it's in sort of chronological order. So the first point is to notify the CE. So variety of people might do that, contractor or subcontractor, obviously subcontractor if you're on a subcontract, and in some cases the project manager. So this is just a notice. So it is basically, this is a CE, probably saying, you know, which CE it is, and possibly saying, you know, what the issue is, what's happened that means it's a CE. No need to cost anything or provide masses of detail. It is just a fairly brief notice. There are timescales, and we'll come back to that. But once that notice of a CE has been issued, we then go down to the third bullet point, which requires the project manager or the contractor in a subcontract to make a decision, is it a CE or isn't it? And then respond to the contractor or subcontract on that basis. If it is a CE, then the contractor in a subcontract or the project manager in a contract will also ask for a quote to be provided, and that's when the party carrying out the work actually starts to prepare the quote. Be careful, because the quote includes the cost, the time, and the cost of the time. So all three of those elements. So if you're the party doing the work, please don't forget any of those, because that then makes there's a real risk that you're going to miss out. And the other point that I was going to make there is that so yes, as regards those three, in some respects it's really convenient because they're all together in the quote in the compensation event. But bear in mind, it's the equivalent under JCT of a variation or a change, which is about clause 5, I think, of JCT, an extension of time, about clause 2.26 of the design and build, and also loss and expense, which is about 4.20. So in JCT, you've got 3 different sections of the contract. Under NEC, you've just got the one, but don't do as clients have occasionally done and forgotten to include the extension of time element in a quote. So the quote submitted, including all those 3 items, and then it goes back to the PM. So this is like a game of tennis from one party to the next. So then the PM decides whether to accept the quote or not. And if the PM doesn't accept it, it has various options, one of which is to ask the contractor or subcontractor and a subcontractor to try again, do a different quote. And the other one is for the PM just to say, look, contractor, leave it, I'll make the assessment. And in that regard, there is a further timescale for the PM to do that. So if we can move on to the next slide, please, Jan. Yeah, so these are the clause numbers that we've been talking about. So we've got, if you look at clause 61, notifying a CE, 62 is the quotation, preparing the quotation. 63 is assessing the quotation. 64 is the PM assessing the quotation, and 65 is implementing. So just a note about implementing. It sounds in ordinary English language as if that's when the contractor or subcontractor carries out the work that is the subject of the CE, but that is not what it is about. And in fact, it's the opposite, because the contractor and subcontractors have to keep progressing their work whilst this process is ongoing. Implementation is about either PM accepting the contractor's quote or making its own assessment. So at that point, whichever route the PM goes down, a figure, an amount, and an extension of time will have been assessed one way or the other. And at that point, it's implemented, which means that it's incorporated into the contract price for the purposes of the contractor applying for payment. So in an activity schedule, so an option A form of contract, fixed price based on the activity schedule, the CE price gets incorporated into the activity schedule and contractor can be paid for it. So that's the process. Note that the flow charts that I often refer to in these webinars consist of 20 pages for all these different processes. Also, the guidance notes are helpful. I also want to mention early warning notices, EWN, because they are in a separate clause, clause 16.1. They apply to compensation events, but they are wider than that. An early warning notice is a notice issued by either the contractor or PM, or contractor or subcontractor and a subcontract. And it's wider than a compensation event. So it's basically something significant has changed. The price, the scope of the works, the time for the work, a health and safety issue, something like that. It might be a compensation event, it might not be. It might be that we don't know at the time that it happens. The critical thing is that the contract requires that the early warning notice is issued as soon as one of the parties becomes aware that it has occurred. So obviously, if one party becomes aware and doesn't issue it, then they are in breach of contract, and I'll come back to that. Now, I would like to have a look, before we move on to the next slide, at the clause 60 compensation events, just to show by comparison that they are quite prescriptive in comparison to what we see in JCT. So with JCT at clause 5, changes or variations, whatever you like to call them, what we have is kind of quite a wide, if something changes in the nature of the works, the employer's requirements or contractor's proposals, or the access, so it's all quite vague, but it's basically if the scope changes, or something in the way that the work was intended to be carried out changes. NEC is far more prescriptive than that. So if we start with a couple of CEs that you are probably aware of. The first one is clause 60.1.13. So I would call it compensation event 13, and it's weather. So bad weather entitling contractor to time and money. Now, if you're familiar with NEC, you'll know that in comparison with JCT, which looks at exceptionally adverse weather, which is quite subjective, the NEC is very prescriptive in that the claim fails or succeeds based on what the weather records, the meteorological records, are for the particular area at the particular time. And that's all by reference to the weather data that's relevant as per the contract data part 1. So it's quite prescriptive. You've got measurements, and if you come within those measurements, then there's a CE and it needs to be quantified. Similarly, CE 12, so that's clause 60.112, which is physical conditions, so typically ground conditions. It's similar to, JCT doesn't mention ground conditions at all because it's the contractor's responsibility. NEC does, but it's quite prescriptive. So the contractor to succeed in a claim has got to show that the conditions that have been encountered are within the site that it's working on, and that they're such that the contractor wouldn't reasonably have priced for them. And in looking at whether you would reasonably price for certain ground conditions, you take into account a number of items. So including the site information, which is in the contract, but also including publicly available information, which is referred to in the site information, also taking into account visual inspection and what should have been apparent to the contractor, and also taking into account information which an experienced contractor would reasonably have been expected to obtain. So there are a lot of hoops for the contractor to jump through in order to establish that CE. So the main ground for a CE, in my experience, certainly is number one, so clause 60.11, which is a change to the works information or a change to the scope. So that's relatively simple. There are others which again are prescriptive, and they're similar to the JCT grounds, but they are very prescriptive. So they're things like the CEs 2, 3, 4, 5, and 16. So for example, 16 relates to materials, facilities, sampling that the employer or the client is for tests and inspections that the employer is required to provide, providing it is all stated in the works information. So that's why that one is quite prescriptive. It can't be that the contractor just says to the employer, this is a compensation event because I was expecting you to provide all this sampling or these testing facilities and you haven't. It's got to be that the contractor can say, look at the scope, look at the works information. You, employer, were going to provide these materials, facilities for testing and inspection by this date, and you haven't done so, and therefore it's a compensation event. And the others are very much the same, so very much referring to what, if anything, the employer or others were going to provide as set out in either the scope or works information in the contract, the accepted programme, or in the contract data. So it's not just a case where contractor or subcontractor can say, oh, well, I was expecting this and it was reasonable to expect it. It's usually got to be in a specific document. And again, it can't be, some of them relate to, what was other things that the employer was to provide by reference to the accepted programme. So in that case, it's not sufficient for the contractor to say, oh, well, I was expecting this. It's CE under that clause that refers to the accepted programme because the works information says it was to be provided. No, it's got to be in the accepted programme. So you've got to comply with the actual requirements in the clauses. There are then a couple of others. I mean, there are over 19. Number 19 is effectively that force majeure clause that we talked about a lot in COVID. So something occurring that neither party has caused and that neither party could have reasonably have anticipated when they entered into the contract. And if that causes delay then it's a compensation event. The final one I want to mention is CE 18, so that's clause 60.118, and that's simply a CE where the employer is in a breach of contract, where it's not one of the other compensation events. And I'm going to come back to that. It's rarely used, and that's possibly because there are other remedies under the contract. But in some cases, I think it's a useful one to use in terms of keeping the processes within the contract moving. So if we can move to the next slide, please, Jan. So these are the timescales for that process that we started looking at. So clauses 61 to 65 of the contract. If you remember that first one, clause 61, was notifying a CE. So the first line here says contractor's CE notification to the PM. So if it's a CE that the contractor has to notify, it doesn't have to notify all of them, but if it's one that it does notify, it has 8 weeks to notify it, and that's 8 weeks from becoming aware of it. Bear in mind, of course, that the contractor should almost always have already issued an early warning notice. So pretty much it should be day one when something happens, early warning notice is issued, and then within 8 weeks, the CE is notified. Contractors and subcontractors beware, though, that, don't always measure the early warning notice as the start date for the 8-week time limit, because if something occurs on site today and the early warning notice is served, for example, on Thursday, if contractor then serves the CE notification within 8 weeks of that early warning notice, then it's going to be out of time. It needs to be 8 weeks from today's notice, from today, not 8 weeks from the early warning notice issued on Thursday. So this is all at clause 61.3, as it says at the end of that first line, and then I've said it's a condition precedent, which is basically legal speak for saying it's a killer clause. Basically, that if the contractor fails to notify within that time scale, then it's still got to do the work, but doesn't have any entitlement to any extra time or any extra money. That's why I say it's a killer clause, because contractor loses its entitlement to any remedy just for not notifying it. Doesn't matter if the works would have always had to have been done. That's not the test. The test is simple. Did the contractor notify within the contract timescales? So, that is a real risk for contractors. So anyway, that's that first process. So in our game of tennis, we've got contractor has notified the CE to the PM. So the PM then has an action, which is our second line. The PM needs to make a decision. As it says there, it's got a week to do it, to either agree to tell the contractor, yes, it is a CE, or no, it isn't. Technically, if the answer is no, it isn't, that's where the process ends. I'll come back to that. If it's yes, it is a CE, then the PM should also go on and say, please, contractor, provide a quote. For contractors and subcontractors in the room, if they don't, my advice would be to go back to the PM and say, oh, clause 61.4 says that you've also got to request a quote. We are preparing it, but would you please just confirm that you agree that? What about where the PM says, I don't agree that this is a CE? Technically, it all comes to an end, and the idea is that the contractor can start an adjudication. In practice, that's extremely unlikely to happen. My advice usually is to nevertheless prepare the quote just to keep the ball rolling, so that the PM and the client don't suddenly become under some misapprehension that contractors accepted that position and is happy with the rejection of its CE. So we've now got to the position where the ball's been passed to the contractor, and the contractor has been asked to provide a quote. So third line down, contractor then has 3 weeks to prepare that quote and issue it to the PM. Contractor does that, and again, the ball's back in the court with the PM. So the PM has 2 weeks to either accept or reject the quotation. If it's accepted, great, everybody agrees it, and then it can be implemented, incorporated into the activity schedule if you're on option A, for example, and paid EOT extend the programme in accordance with the agreement. If the PM doesn't agree it, they can ask the contractor to review and provide another quote, or more likely the PM will make its own assessment, which usually involves the PM reviewing the quote, crossing a few things out that they disagree with, possibly reducing any extension of time, etc., and submitting it back to the contractor and saying, this is my assessment. And if the PM's going to do that, they've got to do it within 3 weeks of notifying the contractor that they're going to make their own assessment. So that's the process. The 1 killer deadline is that 8 weeks that we talked about at the start. But you'll see there that there are lots of things for the PM to do. So what if the PM misses a deadline? Well, that's covered in that final bullet point, which covers all of the PM's actions. And what happens here is it's not a killer deadline to start with. So if the PM misses the deadline, yes, it's in breach of contract, but they're not condition precedent clauses, so it doesn't really go very far. But the bullet point describes a default provision which allows the contractor, once the PM has missed its deadline, the contractor can write to the PM, tell them you've missed your deadline here, give them another 2 weeks, and if the PM still doesn't respond within that 2 weeks, then the PM is deemed to have agreed whatever the contractor has submitted in the previous step. So in circumstances where we've got the situation, so the second from bottom process where it says PM's response to contractor's quotation 2 weeks from receipt. So contractor's sent the quotation, 2 weeks go by and PM hasn't responded, breach of contract, but it's not a condition precedent. So the contract at that point, 2 weeks and 1 day, sends a letter or an email to the PM, you've missed this deadline, you should have responded in 2 weeks. We are giving you another 2 weeks. And if the PM still doesn't respond, then the PM is deemed to have agreed what it hasn't responded to, namely in this case, the contractor's quotation. So that's great news for the contractor. This is quite a valuable tool. Having said that, you know, I'd be really surprised if a PM missed it, because obviously they're given a timescale and then a reminder before the default provision applies. But I have had an adjudication where a client was awarded over £1 million just for that situation where PM did miss that 2-week reminder deadline. So that's the first point I want to make on that. What often happens is those reminder clauses are often deleted via the Z clauses, so via the amendments to the contract. Understandably, because they don't favour the employer or the client, so they don't like those clauses, so they remove them completely, which then arguably leaves the contractor with very little remedy if the PM fails to engage or comply with the deadlines under the contract, except that if we go back to what I said earlier, if the PM doesn't respond to those within those deadlines in the contract, it's a basic breach of contract. It hasn't responded within the 1 week, the 2 weeks, the 3 weeks, whichever one applies. breach of contract. And of course, if you remember, we looked at that compensation event 18 under clause 60.1.18, which is a compensation event where there's a breach of contract by the employer or the client. So if those default provisions have been deleted, contractors, subcontractors might find that if PM doesn't comply with the initial deadlines and contractor stroke subcontractor issues that the CE number 18, that will persuade the PM to quickly respond and keep this CE process moving. So if we can have the next slide, please. So just some points. So the first bullet point deals with that 8-week deadline. Second bullet point just warns that it's 7 weeks under a subcontract. So please be careful, because of course that's the killer deadline. Also, both contractors and subcontractors, be careful, because those deadlines are often shortened via the Z clauses. So quite often they're reduced to 3 or 4 weeks to notify. So please be careful about that. Now, third bullet point, I'd said earlier that some compensation events the contractor stroke subcontractor has to notify. Others, it's the project manager or supervisor who has to notify. So the contractor and subcontractor don't have to worry about that killer deadline for some of them. And they're described at 61.1 as items where the PM or supervisor, and it's quoted there, is given an instruction, issues a certificate, changes an earlier decision, or corrects an assumption. So there are a variety of things there. Rather than kind of trawling through and trying to work out which apply to which, if you look at the bottom bullet point, the GN, which is the guidance notes for NEC, states with regard to this clause 61.1, the CEs where it is for the PM or the supervisor to notify. So it lists them there, 1, 4, 7, 8, 10, 15 and 17. So critically, that CE number 1, a change to the scope or a change to the works information, is a CE that has to be notified by the PM or the supervisor, not by the contractor. So that's sort of some help to contractors with with this killer deadline. But also it's bear it in mind, because I have seen instances where employers and clients have said to contractors, you didn't notify this, the E1, within the deadline, so you're time barred, you're not entitled to anything. So, just be aware of that. Having said that, my attitude as a contractor or subcontractor, taking into account that if you feel that it's a compensation event, you're looking for extra time and extra money, my view always is that even if it's not a CE that you're to notify, it's probably best to notify it if the PM or supervisor hasn't notified it, just again, so that you're managing everyone's expectations and you're setting a kind of, you're setting a note that you view it as a CE and that you will be progressing it. So if we can have the next slide, please. We can move on. That's just kind of covering in sort of real time the process that we've just been looking at. So okay, some other provisions under clause 61. So the first one is about the PM issuing instructing a quote for a proposed instruction. So I've already said that we talked about implementation under clause 65, and that's not about contractors sitting back and not doing the work, the CE work, until the cost and the time's been agreed. The implementation's a very different point to that. And that, the opposite is true, in that the subcontractors just got to get on with the work whilst this process that we're talking about now progresses. The exception to that is this clause 61.2, where PM issues a quote for a proposed instruction. And the key there is the underlined word proposed. Now, this is the facility, and it's in line with the sort of general NEC ethos about no surprises, particularly for the paying party, where typically it would say something like, the client, the employer, is thinking of, instructing this change. What's the quote? Effectively, what would it cost if we instructed this change? So in that case, the second bullet point says it's the exception to the rule. So as you would expect, the contractor must not start this work. All it's being asked to do is to provide a quote in the event that the work is instructed. If it's not clear, do feel free to approach the PM to get some clarification. Is this a proposed instruction under 61.2? Just clarifying, we're not going to start the work, you just want to price it so that the client can consider whether or not it wants to have this work, have the work changed depending on what the cost is going to be. Third bullet point down, we've talked about early warning notices. And this is another one where the clause at 61.5 provides the employer's remedy where the contractor fails to issue an early warning notice. Note that there is no specific remedy where the employer or the project manager failed to issue an early warning notice, but they still have the obligation to issue one. So again, in that situation, if as a contractor or subcontractor, you consider the other party has failed to issue an early warning notice when they could have and should have, so they knew of something that was going to change the cost, the nature of the work was a health and safety issue, was going to change the timescales, then again, it's a breach of contract. So, I would suggest issuing that 60.118 CE notice to say, it's a compensation event because it's a breach of contract by the employer or the client. But as far as the contractor failing to issue an early warning notice, if it transpires that it is a CE compensation event, then what clause 61.5 says is that the value of the CE and the time to be allowed with regard to the CE is based as if the early warning notice had been issued. So typically that would reduce the cost and the time that the contractor would be entitled to. So it's basically penalising the contract for not issuing the early warning notice. And the logic would generally be something like clients saying, if I'd known, this was going to be a CE, if I'd been given the early warning notice, we could have done something to mitigate the cost. We could have stopped it altogether, so it mightn't have cost anything, etc., etc. The fourth bullet point down, the project manager can request a quote based on an assumption. That's 61.6. A nice, easy example of this is that CE has occurred, possibly because of a change in the scope, and the PM asks the contractor to provide a quote, but says to the contractor, look, make an assumption when you submit the quote, assume that the ground conditions are X. So it's all favourable ground conditions, for example. And then what happens is the quote's provided on that basis, work is carried out, obviously, and then contractor encounters ground conditions which are not the most favourable. At that point, that is a new CE based on an assumption happening. So the contractor would notify the CE, and you go through the whole process again of submitting a quote in regard to those non-favourable ground conditions. So the contractor can get compensated for the time and money relating to that. So hopefully you can see there wouldn't be any double counting, because it would just be the cost and the time relating to that very discrete point about the ground conditions, to the extent that they're not the most favourable. And then finally, a compensation event isn't notified after the defect state. Next slide, please. Yeah, project manager can require alternative quotes. The other point to bear in mind when we looked at those deeming provisions, so where the contractor has to give that reminder in circumstances where the PM fails to accept or reject a quote. When the contractor gives a reminder in circumstances where it's given alternative quotes, the reminder must state which quote the contractor deems will have been accepted. It makes sense really if you've provided two quotes and then you give a reminder to the PM that it hasn't accepted or rejected, and that reminder means that if the PM still doesn't respond in a further 2 weeks, that it's deemed to have accepted the quote, then you need to specify which quote they're deemed to have accepted. Next one, so next slide, please. We've already covered that bit about the quote covering time, money, and the cost of the time. And we've covered, so we've covered that default position quite a lot. It's interesting, the guidance notes, so GN, second bullet point, talk about 62.6. And I think sometimes it's quite helpful to quote the guidance notes if the PM isn't particularly cooperating. The bit that I like here from a contractor, subcontractor perspective is the bit, it is important that the PM does not delay the assessment of CEs by, for example, waiting until the changed work is complete before deciding whether or not to accept the contractor's quotation. I must say, I have seen that occur a lot. And it's a good one to quote because hopefully, along with, these deeming provisions or using that CE 18 about being in breach for not progressing the process, it's showing the project manager that they shouldn't be doing something which they're doing, and nobody likes to be told that they're in the wrong. So, usually you would expect the project manager to pull their socks up and apply the contract properly after that. Next slide, please. Okay, so for assessing compensation events, first bullet point, in terms of the financial impact, the time is actually quite similar, but it's assessed as the effect of this that the CE has upon the actual defined cost of the work already done and the forecast defined cost of the work not yet done. Come back to that. Plus the resulting fee. So the fee is the fee percentage in the contract data part 2. So basically that's the overhead and profit and a few other bits and pieces. If we go back to those first 2 points, so it's effectively about what we refer to as the switch date between the actual and the forecast cost. So we're looking at defined costs, so they're the costs that are listed and set out in the schedule of cost components, which we'll be looking at in next month. So we're looking at the actual cost of the work already done and the forecast work for the work not yet done. Now that makes sense, but it's not quite that. So if we can move on to the next slide, just to talk about the switch date, because we had a lot of controversy about this, probably about 5-6 years ago. It seems to have calmed down since then, but we have different switch dates basically. So we've seen that for some compensation events, it's up to the PM to notify them. Do you remember in the guidance notes, there was a list of the CEs for the PM to notify? So the switch date for those compensation events is when the PM instructs the issues whatever instruction it is. So it's not when they notify the CE, it's when they issue the instruction. So I would imagine that there would be very little work that has already been done at that point. I would imagine most of the quote will be on forecasted work, just because the PM has just instructed the contractor to do that work. In contrast, so the second bullet point, the switch date for the contractor notified CEs, so the remaining CEs, the ones that the contractor has to notify within that 8-week deadline, 7 weeks for subcontracts. The forecasting starts when the contractor notifies the CE. So in this case, there is quite some potential for the actual cost of the work to substantially apply here. Because if you just think about it, if a CE occurs today, might issue an early warning about it tomorrow or Thursday, for example, but the 8-week time limit starts from today. So contractor issues a CE notice 8 weeks from today. It can issue it earlier than that, it just can't issue it later. But if it leaves it for 8 weeks and then issues it at the very last moment, the forecast cost starts from then. All the work done from today's date up until issuing that notice for that 8-week period is done on the basis of the actual cost incurred by the contractor. So in those situations, in some instances, the contractor might want to leave it quite late. Obviously not beyond the 8 weeks or the 7 weeks in a subcontract, but leave it late so that its quote can be on the basis of the actual cost incurred. It very much depends upon the circumstances, I guess. Also, the guidance notes make it clear that the switch date doesn't change. So we've seen that the PM, when you go through that process, PM gets contractor's quote and can say to the contractor, I'm rejecting that. Here's it back. I'd like you to do something different with it and resubmit it. The switch date doesn't alter at that point. It's still taken from either of those two dates, depending on who notified the CE. So if we can have the next slide, please. I think we've covered, we've covered all of that. Oh, sorry, no, the fourth bullet point, keep going, that's fine, Jen. That fourth bullet point is just to note that assessments of quotes for compensation event work assumes that the contractor reacts competently and promptly and that costs are reasonably incurred. That is the mechanism. It's the sort of balancing that allows the PM to check the quote and say to the contractor, you've said this is going to take 6 weeks. You know, that's not at all reasonable. It's more like 1 week. So in the quotes, contractor can't just say, you know, this is going to take me 3 years to complete this CE. It's going to cost, you know, £27 million. The assessment, it has got to be based, whoever prepares it, whether it's the quote provided by the contractor or the assessment by the project manager, it's got to be on the basis that the contractor basically operates efficiently. Next slide, please. We can move on. So that's just assessing delay, which is similar to the way in which the financial element is calculated. So that's just the circumstances where the PM can make its own assessment. So we've seen that already. So if we can move on to the next slide. And that just talks about the default provision with regard to that which we've already looked at. So if we can move on to the next slide, please. Implementing CEs, we've talked about this already. It's not about carrying out the work, it's about implementing the either assessed value of the CE if the PM assesses it, or the accepted quote if the PM accepts the contractor's quote. So incorporating that into the contract. So just to be clear, there are a number of scenarios. So the project manager might accept the contractor's quote. in that situation, it will be really difficult for the contractor to then say later on, actually, that cost me far more money, or it took far more time than I'd anticipated, so I want some more. I used to say it was set in stone in that you couldn't, contractors couldn't then challenge it. But in some circumstances, as with all issues to do with construction law, it's a little bit fluid, particularly in adjudication, but it's tricky. On the other hand, where the PM has accepted the contractor's quote, it doesn't mean that it's binding on the client or the employer. They can still go to adjudication and get that PM's acceptance reversed, albeit it would probably be an uphill struggle for them for obvious reasons. The PM's a construction professional, makes the decision at the time, probably for good reasons, we assume for good reasons. If the employer's challenging it, it's typically going to be several months down the line. So, as I say, it'll be an uphill struggle. In circumstances where the PM makes its own assessment, then obviously the contractor is free to challenge that. Often what happens is the contractor will keep trying to talk to the PM, trying to talk to the client to try and get the CE agreed at a value and timescales that are acceptable to both parties. But if that's not possible, the contractor can go to adjudication and get an adjudicator to make the decision. Ditto the client. So if the PM makes an assessment of a CE, the client can still adjudicate for a different result, presumably a lower payment or a lesser extension of time. Again, it will struggle if it's trying to contradict what its PM has done. If the contractor's quote is deemed accepted under those deeming provisions, then the client again is entitled, once it's paid, to effectively go back to adjudication and look at the merits of the claim. So you might say, well, as a contractor, what's the point of pursuing the deeming provisions? Well, actually, it means that that quote's accepted, it's got to be paid, and then it's up to the employer to prove that money has to be paid back to it, i.e. that the CE was overinflated. So that's everything on that slide. So if we can move to the next slide, please. Okay, that's just a checklist. So we can move on from that. It's self-explanatory, taking account of what we've discussed, and just a sort of key points, again, self-explanatory. So if we can move on so that we can look at the one and only case regarding compensation events, which is this Northern Ireland Housing Executive case, 2017. It's Northern Ireland case, so it's persuasive for our courts in England, ditto Scotland, ditto Wales, but not binding on them. So, other courts may come to a different decision. Also, it's a professional services contract, so that might encourage the English courts in particular to come to a different decision. Also, in this case, neither party complied with the processes that we've just been through. Having said that, the case went in the favour of the paying party, the employer, and it was the project manager substantially who hadn't complied with the contract mechanism. And so what happened was the project manager issued a change to the scope. So as we've seen, that's CE1. Under those guidance notes, it's for the PM to notify the CE and request a quote. In this case, the PM did neither, didn't notify the CE, didn't request a quote. Consultants, as consultants often do, just got on with the work, wanted to do a good job, etc. Did the work, and I think got to the end and thought, oh, that's a CE, we need to work out how we're going to get paid for that. So having done the work, they submitted a quote, but they did it on the basis of the switch date that we've looked at, i.e. because it should have been notified by the PM from the date of the instruction changing their scope of work. So they did it in line with the contract, but of course it meant that a huge amount of the work was forecasted when by this point the consultant had carried out the work, so it knew how long it had, how long it had taken, what it had involved. And the issue, if we can move to the next slide, the issue that arose was whether the court should value based on the quote which had been provided after the work had been completed, or on the basis of the substantiating the actual time and the actual cost of the work. And the court went for the latter. So basically, how you would substantiate a claim under a JCT contract. A little bit disappointing because, of course, it flies totally in the face of NEC and creates a problem in that we've spent a whole hour talking about a process of providing a quote. But this effectively means that if a matter goes to adjudication or court, contractor will have to provide the quote, but the dispute will substantially be resolved based on the contemporaneous documents showing how much time was spent, who spent that time, what materials were required, etc., for that specific CE. So it's not a helpful case for contractors and subcontractors because it means they've got to provide the quote still, which is often time consuming, but they've also got to do that JCT bit of keeping records of the costs of things. So cost of materials for that particular CE. So, if you're building a building, you're going to have bricks in the ordinary course of the building, but if a CE requires extra bricks, right, well, we need an invoice to prove the cost of those extra bricks, how many were required and what did they cost. If you've got, several people working, we need timesheets to show who was working on that CE and what timescales they were working on it. It's not enough just to say, well, we had 30 people on site. Some of them were working on that CE for some of the time, but, we're not sure what it is. Also, the thing is that, contractors, subcontractors might think, well, we're not going to go to court over this CE or in fact, any of this, this dispute, and we're not going to go to adjudication. We just want to negotiate a resolution. But what you might find is that without that supporting documents, the PM and the client might just say, well, if you haven't got that supporting documentation, you're going to get nowhere in court or in adjudication. So there's no incentive for us to try and negotiate with you. So it's not a great position to be in, I don't think, but my advice would be belt and braces, prepare the quotes, but also keep the documents to substantiate. So I think, Jen, if we can just move to the next slide, I think that's everything. And I have a feeling I saw a question. Fortunately, we've got 3 minutes to go, which is pretty amazing for me.
Yeah, no, thank you very much, Sarah. There is a couple of questions. One of them came in sort of near the start. So that was